So the Supreme Court issued a new 6-3 order, which has completely shaken up a critical issue in our country and is creating a new battle between the state of Texas and also the Biden administration over the border. So we need to talk about what just happened after this order and what impact it is having. Now, real quick before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are not actually subscribed to this channel. So if you enjoy this content, if you want this content to get out to more people, if you enjoy it, please consider subscribing to the channel. It's completely free to do. It's a way to support the channel. It triggers the algorithm and lets it know that it needs to push this out to more people. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, we need to talk about a new 6-3 decision that was recently issued by the Supreme Court, which is now being used to support the state of Texas in their dispute over the Texas border. The state of Texas is using this decision to support their right of self-defense. Now, a couple weeks ago, the Supreme Court issued a 6-3 decision in a case called Labrador versus Poe. That decision placed limitations on lower courts being able to grant overbroad universal relief in cases like this one. The state of Texas is now using that decision to challenge and ultimately strike down the universal block that the lower court put in place against their SB4 law. The Supreme Court Labrador decision now being used in this case is a huge development, and the Biden administration is just actively fighting against this. They are desperately trying to avoid that new Supreme Court decision being used and applied by the Fifth Circuit. Now, we need to do some background on this case and the prior Labrador case so you guys understand what is happening and what are the implications of what the Supreme Court did. Texas SB4 effectively makes it a crime for an individual to violate federal law by crossing into Texas at any location other than a lawful point of entry. It also makes it a further crime for the illegal re-entry of any person who has already been denied admission into the U.S. or was previously removed from the United States because they unlawfully entered. Finally, the SB4 law allows judges in the state of Texas to issue orders requiring those individuals who crossed the border illegally to then have to return to the foreign nation where they crossed. This bill was challenged by the Biden administration, and a district court on review issued a preliminary injunction which prevented Texas from enforcing all aspects of SB4. The lower court in this case placed a universal preliminary injunction on SB4, essentially broadly blocking all of its enforcement. Texas appealed that decision and that injunction up to the Fifth Circuit. In response, the Fifth Circuit issued a temporary administrative stay on that lower court's universal order. That means that originally, through an administrative stay, the Fifth Circuit halted the universal block of SB4. Various cases were then consolidated, and then the plaintiffs filed for Supreme Court emergency intervention. They asked for the Supreme Court to step in early and remove that Fifth Circuit administrative stay. They wanted the block of the universal injunction to be removed. Well, we received an order from the Supreme Court denying the Biden administration's request to vacate the administrative stay. That means that the Supreme Court decided in favor of leaving the temporary block in place, at least temporarily, against that universal injunction. So they sided against the Biden administration. Now, very curiously and very interestingly, in response to that Supreme Court order, that same day, the Fifth Circuit issued a new order removing their own administrative stay. Then the day after that, they held a hearing on a stay request, a true stay order, and they issued a 2-1 order denying the state of Texas's request for a new stay. What that means is that the Fifth Circuit on their own decided to remove that block that they had in place on the lower court universal injunction. Then just a few days after that, the Fifth Circuit heard oral arguments on whether they would in fact grant a preliminary injunction in favor of the Biden administration, essentially put in place their own universal injunction and uphold what the lower court did as far as the universal block on SB4. From the arguments, it sounded like the Fifth Circuit would still rule 2-1 in favor of the Biden administration and rule in favor of a universal block on SB4. But during those arguments, there were some concerns by some of the judges on whether or not the U.S. government could in fact seek this type of universal equitable relief against the state of Texas. There was a lot of dispute during the hearings, especially from one of the dissenting judges, Judge Oldham, who has agreed with the state of Texas that the government cannot seek this type of relief, they cannot file this type of lawsuit, and ultimately that the lower court's decision should be reversed. Specifically, Texas and one of the dissenting judges focused on the fact that now the federal government and these two judges in the Fifth Circuit are allowing a cause of action that was always, pretty much been limited to only private parties and individuals as outlined in a famous Supreme Court case called Ex parte Young. Now, Judge Oldham and some of the other judges also seemed very concerned about the scope of relief that was being granted by the lower court, i.e. that universal injunction that was issued. Well, just a week after that SB4 hearing in the Fifth Circuit, talking about this Texas border dispute and the scope of relief that was granted by the lower court, the Supreme Court then issued a landmark 6-3 decision on an emergency application in a case called Labrador versus Poe. And in that Labrador case, it answered a lot of the questions that happened in the Fifth Circuit. In that case, the Supreme Court stated that the lower courts should not issue universal preliminary injunctions which go beyond the scope of relief, which would only cure the named plaintiffs in the lawsuits. Essentially, the Supreme Court said that lower courts should move back to the principle of granting more limited scope of relief instead of universal injunctions. In his concurring opinion, Justice Gorsuch stated that ordinarily injunctions like these may go no further than necessary to provide interim relief to the parties. In this case, however, the district court went much further, prohibiting a state from enforcing any aspect of its duly enacted law against anyone. Today, the court stays the district court's injunction to the extent it applies to non-parties, which is to say, to the extent it provides universal relief. That is a welcome development. So that is what Justice Gorsuch said, and a bunch of other justices said in concurring and joining that opinion. What that statement means is that universal, statewide, and likely nationwide preliminary injunction relief is improper according to the Supreme Court. The state of Texas is now using that decision to attack the universal block on SB4. The state of Texas filed a 28J letter to the Fifth Circuit to essentially notify them of what that Supreme Court recent decision said. In the letter, the state of Texas states that in Labrador, the court stayed a pre-enforcement facial injunction of an Idaho law, with a majority questioning the propriety of non-party statewide injunctions. 3 justices found that the state was likely to succeed based on the traditional equitable rule that cabins injunctive relief to the actually injured party, noting any other view would allow judges to govern an entire state from their courtrooms. They go on to say in this letter that 2 more justices agreed the state was likely to succeed in challenging the scope of the injunction. So that is the letter that the state of Texas submitted to the Fifth Circuit. What's important about this is they are playing off of some of the concerns that were raised by one of the dissenting judges, Judge Oldham. Judge Oldham already was stating to all of his colleagues about his concerns about the broad-reaching implications of the lower court decision and what the Fifth Circuit was doing in upholding that decision. Now, of course, the federal government is fighting back against the use of that recent Supreme Court decision. In their response, they state that the United States has consistently agreed that courts should not award equitable relief beyond what is necessary to provide relief to the plaintiff. But here, the United States is the plaintiff, and every application of the statute will cause harms to the United States, as the government and the district court have documented. The district court, therefore, went no further than necessary to provide interim relief to the parties. What the federal government here is arguing is that since the plaintiffs here is in fact the quote-unquote United States, it's the federal government is one of the plaintiffs, they argue that they can get broad-reaching universal blocks on laws like SB4. So they're kind of saying that in essence, the federal government has special status, that they can be treated different, and they kind of fall outside of what the Supreme Court was saying in the Labrador case. So this is a very important development in this case. This is going to probably shape the outcome of this Texas border dispute and lawsuit SB4, and it will likely make this issue even more ripe and even more interesting for the Supreme Court to review. I have no doubt that whichever side ends up losing this universal injunction argument in the application of Labrador to this case SB4, they will then seek Supreme Court review. They're going to seek Supreme Court intervention in this case to see if Labrador was properly applied or was not applied properly. So things are getting very interesting in this Texas SB4 case. Now we're seeing new Supreme Court precedent being applied to this to try to remove that universal block on SB4. And now we're going to have to wait and see how the Fifth Circuit rules on this issue. But like I said, the likelihood is that this issue will now probably make its way back up to the Supreme Court. So hopefully you guys found this video helpful. Interesting developments in this SB4 case, and it's likely going to shape what happens going forward. If anything else develops, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.